In this video podcast, we are going to cover the initiative process. So the people under Article 2 of the California Constitution have the power of making laws. They can propose statutes as well as constitutional amendments. And they do so through the initiative process by presenting a petition to the Secretary of State. This written petition must include the text of the proposed statute or constitutional amendment. And before circulating an initiative petition for signatures, a copy has to be submitted to the Attorney General, and the AG then prepares a title and summary of the measure pursuant to the Elections Code. If the Attorney General determines that a fiscal analysis is necessary, then that initiative measure is sent to the Department of Finance and the Joint Legislative Budget Committee for a fiscal analysis. When the title and summary has been completed, which is anywhere from 15 to 45 days after the date of submission, this becomes the official summary date, and the title and summary is issued by the Attorney General's office. The Secretary of State certifies an initiative petition based upon the number of signatures collected, and that's 5% for statutes and 8% for constitutional amendments. And both of those percentages are based upon all the votes cast for the governor at the last gubernatorial election. The proponents of an initiative measure have 180 days for signatures to be obtained, and only registered voters can sign a petition, an initiative petition, in their county of voter registration. A measure placed on the ballot at the next statewide general election occurs, and that election has to be at least 131 days after the measure qualifies for the ballot. Now, an initiative statute, as you might imagine, is approved by a majority of voters, and it takes effect, that approved ballot measure, on the 5th day after the Secretary of State files the statement of the vote for the election at which the measure is voted on. Now, nonetheless, the measure may provide that it becomes operative after that effective date. So a delayed implementation or a delayed operative date can be included in the initiative measure. If the provisions of 2 or more measures approved at the same election conflict, then the provisions of the measure receiving the highest number of affirmative votes prevails. And of course, there are court decisions to help determine when provisions are in conflict, or else more often today, the ballot measures have descriptions of when their provisions conflict with other measures. Now, pursuant to Article 2 of the state constitution, an initiative cannot name any individual to hold an office. An initiative can't name or identify any private corporation to perform any function or to have any power or duties. And so those can't even be submitted to the electors, let alone have any practical effect. Similar to the other 2 forms of direct democracy, the California Secretary of State has prepared information on initiatives in California. Prior to 1960, initiative measures appeared on general election ballots only in November. From 1960 to mid-2011, initiative measures appeared on primary, general, and special election ballots. As a result of the legislature's enactment in 2011 of Senate Bill 202, which is Chapter 558 of the statutes of 2011, from July 2011 going forward, initiative measures can only again appear on the general election ballot. And by the way, ballot measures were not numbered until the general election held in 1914. The Secretary of State has put together a summary. Some of the data could be updated, but between 1912 and 2017, there were almost 2,000 initiatives that were provided title and summary for circulation. And a total of 75% of those, nearly 1,500 of them, failed to qualify for the ballot. So 3 out of 4 initiatives that were submitted to the Attorney General for title and summary never qualified for the ballot. And so about 20% qualified for the ballot. And of those that qualified, about 35% were approved by the voters. Of those that were approved, 40 were constitutional amendments, 78 were statutory revisions, and 14 included both constitutional amendments as well as statutes. 64% of the measures, the initiatives that were on the ballot, were rejected by the voters. There were a handful, about 3, that have been removed from the ballot by a court order, and more than 113 were withdrawn from circulation. Every year, also, the California Secretary of State tracks all pending initiative and referendum measures, and those can be obtained from the Secretary of State's website, which includes a listing of those that have been cleared for circulation to start receiving signatures, as well as those who have reached the 25% signature threshold, and then those that are pending signature verification, as well as ballot measures, initiatives, and referenda that have been withdrawn or have failed to qualify or that still are pending at the AG's office. And that's a short summary of initiatives in the state of California.